come back to it.
Understood, Judge.
You agree with that?
Yes, I do. I do, Your Honor.
Okay, great.
Judge,
Your
we
Honor,
are
we're ready to
streaming on
proceed.
YouTube now, so
Say it again, Ms. Minacchio?
we are streaming now on YouTube.
We're ready, Your Honor, whenever you are.
I'm ready. All right, then. Good morning. We're here in the case of State versus Braley. We're here for a detention hearing. May I please have appearances of counsel?
Good morning, Your Honor. Assistant Prosecutor Tia Minacchio appearing on behalf of the state.
Good morning, Your Honor. For the record, James Porfido on behalf of Peter Braley, who's in the Morris County Correctional Facility.
All right, and is Mr. Braley, can he hear us at this point? Mr. Braley, can you hear me?
He can.
All right, thank you. I see you now, Mr. Braley. Thank you. All right, well, we, as I said, are here for a detention hearing. Before we proceed to the detention hearing, I know that Mr. Porfido filed a notice of motion concerning Mr. Braley's fitness to proceed in this case, and he's requesting that an examination take place. Is that correct?
Yes, Your Honor, that's correct.
All right. Before we get to that, though, let us have Mr. Braley sworn in. Although there's no Bible there, Mr. Braley, do you swear or affirm that any testimony you may give will be the truth in this matter and nothing but the truth?
Yes, sir.
Okay, and can you just state your full name for the record, please?
Peter A. Braley, B-R-A-I-L-E-Y.
Thank you, Mr. Braley. I'm going to ask you a number of questions. This is a first appearance. Counsel, do you agree I should give him his first appearance rights, correct?
Yes, Your Honor.
Okay. So, Mr. Braley, are you currently under the influence of any types of medications that could affect your judgment or your ability to understand what's taking place? You may be under medications, but are you understanding what we're discussing right now or what my question is?
Asking me, have I ever taken any drugs at all?
No, I'm asking you
Or
whether I'm asking you now if you understand. Are you on any types of medications that could affect your judgment right now, or that could affect your understanding of this proceeding?
Unless somebody is putting something, mixing with my food, I would not know that. I noticed
Okay.
this morning when I came down, everybody else was drinking whatever the juice was. But I was the only one drinking hot tea.
Okay, but are you understanding what I'm saying to you now?
I hope so.
Okay, well, let me ask, if at some point in time you don't understand the question that I'm asking you, I'd ask that you tell us, okay?
Yes, sir.
All right, and Mr. Porfido, have you reviewed the charges with Mr. Braley?
I have, Judge, yes. We met at the jail last week.
Do you waive reading of those charges?
Yes, Your Honor, I'll waive a formal reading of the charges.
All right, so, Mr. Braley, please understand that you have certain rights, and you have the right to remain silent. And if you decide to speak and give up that right, anything you say can be used against you in court. Do you understand that?
Yes.
All right. You also have the right to be represented by counsel. In fact, you're being represented by Mr. Porfido in this matter. If at some point you can't afford an attorney, you can always apply for the public defender. And if you qualify, a public defender would be appointed for you. Do you understand that?
Yes.
You also have the right to have your case ultimately presented to the grand jury and considered for indictment. If you are indicted, you have the right to a jury trial. You can give up your right to indictment and to a jury trial if you freely and voluntarily give up those rights, or if you ultimately plead guilty. But I'm cautioning you that you should talk to Mr. Porfido before you give up any rights or if you plead guilty. Do you understand that?
Yes. And
all right. Are you an American citizen? Are you an American citizen?
yes, that.
Oh,
Yes,
right.
sir.
All right. Now, there are several programs that are available for defendant. One's called the Pretrial Intervention Program, and that's for first-time offenders, and it may be applicable in your case. If you're put into the program and you complete it successfully, then the charges against you are dismissed. If that's something that interests you, then you should talk to Mr. Porfido about that. Do you understand that?
Yes, sir.
Are you a veteran?
Yes, sir.
All right. Well, from what branch?
United States Navy, sir.
All right. Please be advised that there is a Veterans Assistance Project which can provide referrals to community resources to address unique services required by veterans, including housing, mental health counseling, substance abuse treatment, financial aid, education, veterans benefits, and other benefits and services. Should you want additional information on veterans assistance, please advise the officers in the pretrial service unit or Mr. Porfido, and they can provide you with that information. Do you understand that?
Yes, sir.
All right. Also, you may be eligible for what's called the drug court program, and that's a program to stop substance abuse through supervision and treatment. If that's something that interests you, again, you should talk to Mr. Porfido. Do you understand that?
I would very.
All right. Very good. Then we're going to go on to the detention hearing at this point. And a detention hearing, the state has filed a notice of motion to detain you pending trial. Is that correct, Ms. Minacchio?
Yes, Judge.
All right, Mr. Porfido, you've received related discovery.
Yes, I have, Judge.
All right.
There's some type of interference in the line
Yeah.
on my end.
Yes, I heard it as well. It seems to have gone away now. Is that correct?
Yeah, there was a lawnmower, Judge, that went by.
Okay, not a problem at all. So at a detention hearing, Mr. Braley, you enjoy what's called a rebuttable presumption against detention. And the state has to prove by clear and convincing evidence that there's no amount of bail or no amount of conditions or a combination of the two that would
Judge?
reasonably, yes,
Judge,
yes,
can you go a little bit slower?
I will.
You don't
Yes,
have-
I will.
You don't have to shout.
Okay.
Well,
I
in your
appre-
case, you're probably talking normally. It's just me.
No,
I've
no,
only
not.
got I only have 50% loss of hearing in this year. And
Okay.
The way
Let me
you're just
let me
shouting at me. Go ahead.
let me say it again for you, and I'll speak at this level. Okay.
Thank you.
You enjoy what's called a rebuttable presumption against detention. And the state has to prove by clear and convincing evidence that there's no amount of bail or no amount of conditions or combination of the two that would reasonably ensure your appearance in court when required, the protection of the safety of any person of the community, and your obstruction of the criminal justice process. Do you understand that?
Yes, sir.
All right, at a detention hearing, you can testify on your own behalf if you wish. You can present evidence, witnesses. You can also cross-examine witnesses who testify against you, and present evidence to the court by way of proffer or otherwise, meaning Mr. Porfido can tell me whatever he'd like to tell me. Do you understand that?
Yes, sir.
All right. Now, if you do testify at a detention hearing, your testimony shall not be admissible in court on the issue of guilt in any other judicial proceeding related to proving these charges. However, your testimony shall be admissible under certain circumstances, and those circumstances are the following: proceedings related to your subsequent failure to appear in court, proceedings related to any subsequent offenses committed while on release pending disposition of these charges, proceedings related to your subsequent violation of any conditions of release, and any subsequent perjury proceedings, and to impeach your credibility should you choose to testify in any subsequent proceedings. Do you understand that?
Yes and no.
All right, what don't you understand?
Well, people keep on saying that I missed a court date. I don't understand that.
All right, no, you haven't missed any court date as far as I know. This is your first appearance in court.
For you, but everybody says, by the way, Jim, if I'm paying you, I don't know, Jim, if I'm paying, supposedly have all this big retainer, and my family is concerned about money being stolen out of that account or using that account. I don't use it. I had so much trouble because I can't remember the first two numbers, and I still can't remember the first two numbers to open the account. They sent an officer up. He tried to do it. Nothing happened. Then,
Mr. Braley, may I interrupt for one moment? I'm going to give you the opportunity afterwards, if you have questions about your account and money, to speak privately to Mr. Porfido.
Judge, I'm aware of it. I did send an email to the jail. He was having some difficulty opening up the phone account and the commissary, getting access to the commissary. The money was deposited there, and I did send an email, and there was confirmation from, I believe it was Captain Patty at the jail, that he was addressing it with Mr. Braley directly.
All right, very good. Then, Mr. Braley, I'm going to continue. Okay, so far you've understood?
go ahead,
Mr.
sir.
All right, thank you. Do you understand also that if the court grants the state's motion for detention, you will be detained? That means you'll stay in jail until the state obtains an indictment against you, which has to be done within 90 days. And if you are indicted, then you have to be brought to trial within 180 days unless there's excludable time. Do you understand that?
Yes, sir.
Okay, then why don't we move to the detention hearing itself? And what is the situation in regard to probable cause? And I addressed that question to Mr. Porfido and to Ms. Minacchio.
Judge, if I may, obviously in light of defense counsel's motion for fitness to proceed, it's the state's position that Your Honor should conduct the questions under 2C4-4 to inquire of the defendant if he understands the nature of the proceedings. And if Your Honor determines that he's not competent or fit to proceed, I don't believe that the detention hearing should move forward. I think that Your Honor would then need to order the mental health evaluation pursuant to the statute, and then we would have to find out if he is currently fit to proceed and understand and assist with his defense. I think that would need to be addressed before we can move forward with the actual detention motion.
I respectfully disagree with you, Ms. Minacchio. There is it happens to be an unpublished opinion that came down from the appellate division that said that when there are situations concerning fitness to proceed, detention hearings should still go forward. So I do intend to go forward with the detention hearing.
Then, Judge, perhaps Mr. Porfido can place on the record whether he's consenting to detention at this time, and then requesting that Your Honor consider the motion for competency, because we had discussed that alternative as well.
In the event that you do that, in either event, I do believe that, and the rules do provide, and let me just cite the specific rule, 2C4-5 does indicate that whenever there is reason to doubt the defendant's fitness to proceed, the court may, on motion by the prosecutor or the defendant, so either, and Mr. Porfido has done it in this case, can make a motion for an examination to take place. I've read the papers in this case. I've listened so far, and I think that there's cause to order that examination. So the question, Mr. Porfido, is are you going to consent to detention with the option to reopen detention after the examination takes place?
Judge, I would say yes to that, because and I would like to just indicate why. Mr. Braley presently has a temporary restraining order issued against him. He's aware of that from his wife. He does not really have a place to go back to. My thought was, Judge, that he does need to be housed somewhere, and there really aren't a lot of alternatives available at this time. The VA hospital is certainly one if the court were inclined to release him. But again, the competency issue is something that I felt was a paramount issue, and certainly a preliminary issue that had to be determined before we could get to where was he going to go. And I thought, quite frankly, Judge, absent all these circumstances with the lockdown and everything else, that he would have been able to be transported to the Ann Klein forensic facility. I don't know if that's going to be something that we can do in any short order at this time, but I think that is certainly would be a normal connection or nexus from the jail to the Ann Klein facility. Mr. Braley and I have talked about that, and other than his sister in South Carolina, there's really nowhere for him to go.
All right, well then, would you like to voir dire Mr. Braley about the fact that he would be consenting to detention at this point with the option to always renew or to reopen detention in the future? But I'd like you to voir dire him so he understands what you're doing.
Okay, thank you, Judge. I appreciate that. Mr. Braley, can you hear me okay? Peter, are you there?
Yes. Yes.
Peter, I want to ask you a couple of questions because we've talked about your situation at the jail and, you know, that there's not really a place for you to be going right now. And we were hoping to get you evaluated while you were in the jail and use that time wisely to see if you're able to go forward in the case and assist in your defense. You understand there really is not a place for you to go to at this time. Do you understand that because of the temporary restraining order that Pat has filed against you?
I thought she was in a nursing home.
No, she's still at your home, and apparently there's been some arrangements made for her to be taken care of at the home. And she did file a restraining order. I spoke to you about that. It's an order of protection that it's only on a temporary basis right now. And I've indicated to the court in the domestic violence proceeding that, and I've sent a letter indicating that I wanted to have the ability to have you evaluated. And also I indicated to them that we needed to figure out how there was going to be a confrontation. In other words, Pat can't come to court. So you're entitled to confront the witnesses against you. So they're working on that now. And that's something that's just happened in the last day or two. But you're aware you can't go back to the house at this time.
I understand. But if somebody were willing to take me, and I had an ankle bracelet on or whatever you guys do, you'd be able to monitor me, correct?
No, Peter, the restraining order does not allow you to go back to the house under any circumstances.
I understand that, but if I had somebody who would take me, and I had an ankle bracelet, would you do that?
Let me
No.
just interject for a second, Mr. Porfido. As I
Sure,
said,
Judge.
if you find a place for Mr. Braley to go, you can always file a motion to reopen detention because that would be a material change in circumstances. So you'd be able to do that if you choose to do that. I don't know if it would be granted or not, but you certainly can make that application. As
And
Mr.
Judge-
Braley, go ahead, Ms. Minacchio.
I didn't want to interrupt you, Judge. I know that there's a room for consultation upstairs in the jail for Mr. Porfido and his client to consult if they want to discuss some of this information that they're discussing right now, because obviously this is being recorded and is live streaming. So I don't know if Mr. Porfido wants to take advantage of some time to speak to his client in private in a virtual meeting room that's, I believe, has been set up with the jail so that they can communicate privately. We would have to go off the record in order for them to do that, but certainly that's an option if Mr. Porfido needs to explain anything to Mr. Braley without having those conversations being recorded in the public.
Judge, that's okay. I appreciate that. Thank you, Ms. Minacchio. But I think that discussing the domestic violence proceeding is certainly appropriate to explain to him that the restraining order is in place and that it prohibits him from going back to the home and having any contact with his wife. I don't know that he knows the parameters of that. I did try to explain that to him when I was with him at the jail, and I'm not sure that he was understanding it then, and I certainly don't know that he's understanding it right now.
But in regard to his detention and staying in jail now so an exam can be arranged, I'd like you to question him concerning.
Yes, Your Honor. Yes.
To that.
Peter, so far, have you followed what has been happening, what's going on with the court and Judge Ironson's questions of you?
I believe so.
Okay. I want to ask you a couple questions about your understanding of being in the Morris County Correctional Facility. You understand that you're going to be agreeing to stay there so that you can have that evaluation we talked about?
I understand.
Okay, I wanted to make sure you understood that because Judge Ironson wants to make sure you understand, and I certainly want to make sure that you are waiving your right to have a hearing or a determination made by the court as to whether or not you would be released.
Temporarily, he can always.
Temporary. Yes, Your Honor, thank you. Do you understand that, Peter? There's really no place for you to go right now, other than to your sister Carol's house in South Carolina, and the judge would have to allow for that.
I could go to somebody else in Pennsylvania.
Okay.
Pardon me?
Okay, who would that be, Peter?
This is live and we're going.
Yeah, it is. It's something you have to tell the judge. If there's somebody that you say is going to allow you to stay with them.
Every time I say anything, anytime I say anything to anybody, it comes back, oh, you got him killed today, or you got this person killed today. I don't want to do that. Even if they're saying something to me and I believe it, and then the next day it's something else. Do you understand, Jim?
I think I do, Peter. I'm trying to follow, and I did discuss this with you. And
I know you're trying to figure out my logic. I'm just talking to you, sir, Jim. I'm just talking to you.
Okay, I'm here, Peter.
You know, I can never remember your last name. I guess what it is like this guy Chris.
Mr. Porfido, I'm just going to interrupt, and I don't know that we should be having these. You should be having these conversations publicly with your client. And I just wanted to know if he was going to consent to stay in jail until the evaluation was going to take place, understanding that he had the right to a hearing with always the option to reopen in the future. But anything else, I think you should talk to your client privately.
Agreed, Judge. Agreed. Peter?
Yes, sir.
Okay, I want to ask you some questions, and I think you've already indicated that you understood that you're going to be consenting to staying in the jail to have that evaluation we talked about, and you're agreeing to that. Is that correct?
Yes, sir.
Okay, and you understand what Judge Ironson said, that we can always come back to the court to ask that your detention be reviewed again and that this matter be reopened before the court, and you would be allowed to present, or I would be allowed to present on your behalf, any issues as to why you should be released and an alternative arrangement that could be put in place if you're not allowed to go back to your home. Do you understand that?
Yes, sir.
Okay. And you are consenting to staying in jail to have that evaluation. Is that correct?
Yes, sir.
Okay. Judge, I think that was what Your Honor was inquiring about, and I just wanted to make sure we were okay with that.
Mr. Braley, I just want to make sure that you're doing this freely and voluntarily. Is that correct?
Yes, sir.
Is anybody forcing you or threatening you or coercing you? Mr. Braley?
I understand what you're saying. I just don't know how to answer it, sir.
Okay. Is anybody forcing you to agree to stay in jail so that exam can be arranged? Understanding that you can always file a motion in the future to request your release. So my question is anybody forcing you?
Whatever I say, it really doesn't matter.
Well, again, I just want to make sure you're doing it freely and voluntarily.
May I, Judge? May I
Yes.
ask you? Peter, do you understand Judge Ironson's question? He just wants to make sure that you're not being forced to make this decision. You're doing it based upon our discussions, and it's based on your own free will. Do you understand that?
Yes, sir.
Okay. Did you understand that?
Yes, sir.
All right, Mr. Braley, you've had enough time you've had the opportunity to speak to Mr. Porfido and ask questions to him.
Just that one time.
Okay. Well, certainly you'll be provided with additional time, but in regard to this issue, do you need any more time to talk to Mr. Porfido? Just about this. Other things you can talk to him about and he'll arrange for that. But about this issue, do you need more time to speak to him?
I'd rather talk to him in person or in a booth that just me and him, the doors are closed?
Okay, is that,
Peter, I'm going to arrange for that. I am making an arrangement for that today to speak to you at the jail to explain everything that's gone on and make sure that I answer any questions you might have of the proceedings and make sure that you understand Judge Ironson and all the things that are happening today. So that is being done.
so is that satisfactory to you, Mr. Braley?
As long as he gives me more than 15 minutes or a half hour, yes.
I'll give you as much time as I can, Peter, as much time as they'll allow us to talk.
And what amount of time will that be?
I don't know that if there's any limitations on that, but we'll speak as much as we can and I'll answer every question you have and hopefully to your satisfaction.
Thank you, sir.
All
Okay,
right,
you're welcome.
So again, Mr. Braley, you're consenting now to waive a hearing with the understanding that you can always file a motion to reopen, meaning that you can always file a motion to be released in the future. Is that correct?
Yes, sir.
All right. Then I do find, based on the questioning, that Mr. Braley does understand that concept, that he is waiving a right to a hearing in that he has freely and voluntarily agreed to detention with the understanding that in the future he can make a motion to be released. Of course, there's no guarantees that will happen. The court will make a decision on that, but certainly Mr. Braley and Mr. Porfido have the right to file that motion. So Mr. Braley will be detained for now based upon the consent. In addition, the court will sign the order that was submitted by Mr. Porfido for an examination. Under these uncertain times that we are in, I don't know exactly how the transport would work, whether or not somebody from Ann Klein or another facility would come up to do the examination, or Mr. Braley will be transported, but I'll leave that to the Sheriff's Department to make that determination.
Judge, if I may, Your Honor would still need to make the findings on the record that you're for the basis of the incompetency evaluation under the statute, and then you can sign the order if you're finding that. But I think Your Honor now separately has to make that finding on the record, and then the order can be signed, and then the state would then provide the discovery to the criminal division's manager's office so that that can go down with him to Ann Klein for the purposes of the evaluation.
Well, certainly pursuant to NJSA 2C:4-5, the court does find that there's reason to doubt the defendant's fitness to proceed. I base that on the testimony that took place here today, as well as the motion and the contents of the motion that was filed by Mr. Porfido. So I do find that that does exist, and an examination should be done, and it should be done by the Department of Human Services. So that order will be signed.
Does Your Honor have a copy of that order that was submitted with Mr. Porfido's motion?
I do have a copy of the order. I don't
Okay.
have the ability to personally sign it, but I will authorize, I will read it over again, and if satisfactory, will authorize the document to be stamped with my name.
Okay,
All right.
Judge.
And again, there was here today, there was some question, certainly as to Mr. Braley's fitness to proceed based upon his responses to the questions and his comments that he made. So I do think that it's appropriate to order the examination. All right, so you'll be detained for now, Mr. Braley. The state would have to obtain an indictment against you within 90 days. And if you are indicted, then the case has to be brought to trial within 180 days, except for excludable time. So I thank you very much, Mr. Porfido, Ms. Monacchio.
Thank you, Your Honor.
One more thing, Your Honor.
Yes.
In light of the judge, in light of your order for competency, I believe under the excludable time statute, this would be excludable time from today's date until the evaluation is completed. So I would ask that I can prepare an excludable time worksheet to provide to the court, but I would ask that Your Honor grant from today's date until, if Your Honor wants to list a control date within 30 days to make sure that the evaluation has at least taken place within that time frame. In light of the coronavirus, I don't know how quickly that will be done, but I think we should at least give it a control date so that he's brought back before the court in light of his detention status.
I think that,
I do agree, Judge. That would be something I would certainly be requesting as well. And Judge, I don't know that we did this, but to the extent that I can, under these circumstances, there is a stipulation as to probable cause. I don't know that we covered that.
oh, that, yes, all right. Well, you would have to you're at 100% correct, Mr. Porfido. A probable cause stipulation would have to be had in this case. I just ask that you go over that also with Mr. Bray.
I will, Judge. I don't have any dispute that there was probable cause. I just, as to the mental element, that was something that obviously is an aside, but certainly there was probable cause to initiate the arrest and certainly for the signing of the warrant.
All right, you want to just explain that to Mr. Braley?
I can, Judge. If you give me that opportunity, I'll just explain to him what that means.
Please, go ahead.
Peter, I just wanted to let you know what I just said to the judge is that we're stipulating, in other words, we're agreeing that there was a basis to place you under arrest. Probable cause is a very low determination that's made by a judicial officer when a complaint is being signed. In this case, the complaint alleges that you tried to commit an assault of your wife, Pat, and that you had within your possession a weapon, namely a pillow. And I believe there was something else, some other charge, but you endangered her welfare and she was incapacitated. What I just indicated to the judge is that there's probable cause. In other words, probably a crime was committed and probably you were the person who committed the crime. That's all I've said at this time. You understand that?
Yes.
No,
Okay.
Yes.
you're not pleading guilty at this time, Mr. Braley, and this stipulation as to probable cause cannot be used in any other proceedings. It's just for today's purposes. Do you understand that?
Yes, Judge. May I say something else before we go?
I don't want you.
No.
I don't want you to talk about the events that occurred.
I'm not going to.
Okay.
But somewhere on my driver's license, it states I'm handicapped, but yet nobody seems to understand that I can't stand up for very long. I need a chair. Or
All right.
if I take,
Peter, I'm going to communicate all these things to the jail, and you and I will be talking in a little while today, and we'll go over everything that you have a concern about, and I'll make sure that it gets addressed as best I can.
Yes, the jail will take care of any medical concerns that you have. So finally, Mr. Braley, I just want to make sure, so you're consenting to or stipulating to probable cause, as Mr. Porfido has said, and are you doing that freely and voluntarily?
yes, sir.
All right, then I do find that you have freely and voluntarily stipulated to probable cause for these purposes only, for the purposes of the detention hearing. So thank you, Mr. Porfido, Ms. Minacchio. The court will sign the order for consent to detention along with the order for the exam to go forward.
Thank you, Judge. And Judge, if I may, I have not looked at that order for a period of time. If there's anything that needs to be modified on that order, I certainly have no objection to that, to allowing the court to make whatever minor modifications, because I used a form of order that I had in another case, and I just wanted to make sure it was completely accurate.
All right, well, if Ms. Minacchio would look at it as well, and if you have any suggestions, Ms. Minacchio, I'd be happy to take them under consideration.
Thank you, Your Honor. Will Your Honor be giving this a control date to come back and granting the state's application for excludable time? I believe defense counsel will be joining in that request for excludable time.
I don't have any objection to that, Judge.
Yes, all right, then we can come back on April 17th. And for now, the excludable time will be from the March 19th through the 17th of April. And that can always be amended, for example, if an exam is done earlier than that for some reason.
Judge, is this before Your Honor? This case, is it going to remain with Your Honor?
Tony,
The matter
do
would be assigned to Judge Taylor.
Judge Taylor has this case.
Judge
And,
Taylor, okay.
Tony, do you have the date that the case is scheduled to return to court? I don't believe Mr. Montanez is there. Let me see if I can find out the date. Just bear with me, please, and I might be able to do that. Bear with me. Detention calendar. Let's see.
It's 4/6.
Tony,
Your Honor, the next date is 4/6.
All right, so right now, so let's make the excludable time until the 6th before Judge
Works.
Taylor for now.
Okay, thank you, Your Honor.
All right, so excludable time from March 19th to April 6th, and then it can be reviewed at that point. All right, so
Thank you,
Mr.
Your Honor.
Braley, you'll be back in court before Judge Taylor on April 6th. All right, sir?
Yes, sir.
All right,
And
thank you.
Peter, I'll be in touch with you today.
Thank you, sir.
All
You're
right, I wish everybody the best. Thank
Thank
you.
you, Your Honor. You as well.
All right,
Thank
that
you,
will,
everybody. I think it worked out well.
all right, that will conclude the hearing. Thank you.
Thank you, Your Honor. Thank you, Mr. Montanez.
Thank you, guys.